Hello, this is Matthew Chan and Robert Kasankis. We are in Jupiter, Florida, and we are co-hosting this show with Oscar Michelin, who needs no introductions. And this is actually our second threesome episode. And Robert always laughs when I say that.
And Oscar shakes his head.
Because he wants to cringe. Is it cringeworthy? Is it cringeworthy?
It's right there. It's right there.
Well, continuing on our little adventures down here in Florida, as you can see, we're just going off the cuff, and Oscar's going to be the respectable one for this episode as well. I've got a list of things. So I've got some things to hit you with, Oscar.
Go.
Well, you're actually the one that brought it to our attention about the tree freshener case. All right? So why don't you kick that off and let us you wrote a blog post on that, on courtroom strategy.
Who doesn't? Right. I mean, who doesn't love Schadenfreude, a little taste of your own medicine here, to see Getty have to pay a trademark infringement claim on the use of a tree freshener, in their images. And I think it was unusual because it was a rather low settlement, $100,000. I think that's probably an indication that they didn't sell a lot of those images, those tree, the images that contain the air freshener. So it was a company in Watertown, New York, that makes those ubiquitous, iconic air tree fresheners, and Getty just sold a whole bunch of images that had those trees as part of the image. And they first moved to dismiss the action. That was denied. And then just a month or so ago, it settled for $100,000.
But the one thing that jumped out at me when you guys posted it, I think you guys jumped on it before I did, is that how can I know it's $100,000? I mean, I was thinking, that was the first thing that popped in my mind, that it's not even confidential. I said, yay, $100,000, and I know about it. They are obviously talking about it, and most settlements are confidential, right?
I don't know that I've ever been involved with an infringement lawsuit that settled without a confidentiality agreement. I don't think I've ever had a case where we settled an infringement case either as a plaintiff or a defendant, where part of it was the usual no admission of wrongdoing,
right?
No admission that my claim is only worth this amount,
yes,
and no disparagement, and also confidentiality and no discussion of the settlement terms, other than to say you normally have a paragraph that everybody agrees on that says the parties agreed that it was, to everyone's mutual benefit to reach an amicable resolution of the claims rather than litigate, and that's it. So this was a little bit weird.
Yeah.
I don't know whether someone dropped the ball or maybe Getty knew it was only 100. They wanted to get that out there. The plaintiff wanted to gloat about winning, and so nobody negotiated for it. But apparently, because they're chatting it up and there's newspaper articles about it. So I was very surprised to see no confidentiality clause.
Well, I'm thinking from a PR point of view, this isn't really good for Getty, but it's better for the other company. They get to sort of brag about it. And I sort of wondered if it was anything similar to like a public apology. Look, we will accept $100,000. We will not pursue, but we reserve the right to talk about this. And I wonder if that was intentional. What do you think? Do you think that's likely?
It could very well have been that says, if you're only going to pay me this, I'm not agreeing to confidentiality. And then Getty said, oh, what the heck? We're going to deny wrongdoing in our press release. And a settlement is not evidence of wrongdoing. So where's the real harm? It's not, look, it's a significant number. No one would want to pay $100,000. But Getty's, a $1 billion company. So while we're chatting here, they've made $100,000. So to them, it's like, all right, let them crow about it. Who cares? It could very well be. I was just very surprised because that's such a standard clause in settlements that I would have thought somebody would have demanded it.
Yeah. Now, I hope I'm not going to be a troublemaker with what I'm going to say, so everyone brace yourself.
Okay.
How's your honeymoon period going? with the
I'm married 25 years.
With the whole Chaga case. Are you still on a honeymoon there?
Oh, no, I think that the honeymoon is over.
Oh, really?
Yeah,
I thought you were still riding high. We're sort of like riding high off of your high. So the honeymoon is over for you,
I'm very, very pleased with the win. We've entered our judgment. I think they're going to appeal. And I think that we can expect, it going to the appellate court and be tied together with the Alaska stock case and the bean case that's related to Munch. Kind of those cases are going up. So I think that our appeal would largely consist of probably saying, let's wait and see what that decision is. But they're going to get their usual suspects to join in on them. But I think that, things have changed since that decision in a number of ways. And I think Masterfile, is watching carefully that case and is going to want to try to undo it for sure. Well,
okay, this is a strictly non-legal argument. We were talking about the Copyright Act, and we were just looking over the registrations. There's something about, there's all forms of media out there. As you know, there's movies, there's music and songs, there's books, booklets, there's paintings and so forth, right. But somehow the stock photo imagery, they're like fairly unique in that they're trying to plow like 1,000, 10,000 registrations at one time. I mean, how can no company, even the big ones, don't try to plow 1,000 books at a time because you just can't write that many at a time, or 1,000 movies, or 1,000 paintings and this and that sort of thing. Does that make sense? But images are so easy to take. Robert could take. He was telling me he could take 300 images, in a few hours. Easily. And then all of a sudden, we're going to try to jam this down the system. And so
you could,
I don't know.
Yeah, you could take 300 images in a matter of minutes with the digital cameras if you don't want to be high quality images.
Yeah.
If you're talking about high quality images or professional level photography, yes, but the laws always have to adapt to new technology.
Well, that's
but
true.
the difficulty is what the digital image industry was trying to do would be the equivalent of Universal Recording artists saying, here's one registration for the entire Universal music catalog, and we want protection for each individual song that we've ever produced, even though it's different artists on different dates and and it's ridiculous.
Yeah.
And what happened is it's tough because this is the only work of art that's worth 20 cents, okay, or $5 or $1, right? That's the problem, is that digital photography allows you to produce this unique work at a very low cost. Anyone can do it, so its value is very seriously diminished. If you want to think about it, even by Getty's prices, $100, $200, right? So if I got to pay $35 every time I register an image that's worth $1 to $25 to $100, it's going to be exorbitant.
And it's not including the manpower involved, to fill out the form and all that stuff. That's. I mean, I've done it a couple times. It's sort of a pain, actually.
Right. Oh, I know. We just got retained today from an artist who was the photographer for a club called the Fillmore East here in New York, which is a legendary rock club. And he was the backstage photographer for the club. And he's never registered his images, even though some of them have become album cover art for many famous artists like The Doors, Hendrix, Rolling Stones.
Allman Brothers.
And we can now, so I said to him, it's very easy. Put them on a disc. Since you took them all, you're the only author. I said it's very different than what these digital image companies are doing.
Yeah.
Your images have a much higher value because who's got a picture of Janis Joplin talking to Jimi Hendrix backstage at the Fillmore East?
That's a good
No
point.
one's ever seen that image. That's a lot more than a cactus or a keyboard, is worth. And then you can use, and the Copyright Office has mechanisms for that. They've always had mechanisms for that. They've never required that photographer to register each individual picture on his own. What the stock photo industry was trying to do is use that method to cover tens of thousands, sometimes hundreds of thousands of images on one registration for various photographers. And then some of them, the Copyright Office allowed them not to even include the actual image. So you just have these automated databases that you wouldn't even know what picture, what artist took what picture, what's the name of the picture. I mean, it would lead to being able to infringe without ever being able to prove that was the image that actually received that copyright. So, I mean, I think that's where the Copyright Office went wrong, is not realizing that these images were taken by many, many different artists at different times, published on different dates, and that the registrations never told people who took which pictures and which pictures applied to which artists or anything of that kind.
So, go ahead, Robert.
No, yeah, I think that's when PACA became involved, and PACA was suggesting to the Copyright Office that, we could do it this way, and, it would save a lot of time, aggravation, effort, and whatnot. And apparently the Copyright Office said, yeah, that's a good idea. Wrong.
Yeah.
So, have you gotten any flack, since then? I mean, now that you've won, and I'm guessing the relations between you are a little cooler than normal now.
Right. I mean, we used to have a relationship. We've spoken about this on the forum. I've even posted on the fact that we were always able to resolve, our actions with Masterfile, unlike Getty. They had these images registered. They were in a different position. We'd be willing to talk to them. But, once again, you pick on somebody who's willing to fight back and has some resources to fight back, and they got spanked. The court said that registration doesn't count. And for the longest time, they were saying, that was Corbis. That didn't relate to us. We do it differently. So this was directly related to Masterfile, saying that your methodology is improper. So now we're basically saying to them, unless you show us that you've re-registered these images, we're going to have to treat you like a Getty image claim, an unregistered image, and that just takes the value of your claim right down.
So for the time being, the Chaga case, as far as you're concerned, is a game changer.
For Masterfile, it is.
Well, for you too, though, the way you negotiate and so forth, right? It gives you a lot more leverage. I've said this before, you just don't,
for so long before Munch came out, that was the real game changer. Judge Preska in New York court, the first time, despite heavy opposition, said this violates the Copyright Act. And I almost felt like Don Quixote, because I had been saying that for so long. And I said, I don't care what and they would always shove that letter in my face that PACA got. I said, I don't care what the Copyright Office says. That's improper. So, it's nice just to have that kind of vindication. But then here, particularly for my own client against Masterfile, who tried to change it up a little bit by doing the three artists, naming three authors, and then sending in the disc of everybody else, it's certainly a clear vindication for that client specifically. But I think it's also important for the Copyright Office to finally see that federal courts want you to follow the Copyright Act. It's that simple. The language is not vague. And I think that's a tremendous game changer, because now you have New York saying it and you have California saying it. And in my opinion, and in many legal scholars' opinion, when it comes to intellectual property, those are the two most important regions in the country, without a doubt, in the entertainment industry and in art it's New York and California, and courts throughout the country look to those two states for guidance on how to deal with intellectual property matters that are new. So it's a huge problem for the digital image industry.
Well, continuing on the master file discussion, I believe this is fallout. Now, Robert, I was only just arrived in Jupiter today, and I had big files, and I had a bad internet connection, so I wasn't able to transmit the files to either you or Oscar. But for the very first time that I know of, Masterfile is issuing extortion letters that have images at $12,500 or $12,000 some dollars per image. So this particular letter had 4 images at $12,000 apiece and 1 image at a discounted $8,000. So the overall extortion letter amount was what, $57,000?
57 and change.
Yeah, $57,000. That's observation number 1. Observation.
Are they naked pictures of the president? I mean, what kind of images?
It was sort of blurry. I think they were just like people. They were business-oriented.
Cactuses.
Yeah, stock. They were stock photos, Robert?
Basically.
I haven't seen them. I'm assuming they're stock photos.
Oh,
you
okay.
know.
Well, I will be posting it. But apparently they classified it as rights managed. So that obviously has some bearing.
Yeah.
Now, the other thing that has come through that came out recently in the last few days is that they're attaching a blank copy of a lawsuit complaint. But it's totally unsigned. There's code case number. There's no attorney signature. There is not a signature of anybody on this thing. It's almost like a Word template of what a complaint might be, and they've attached it. So, I find these two events very interesting, and I'm wondering if they are stepping up the ante the way they send the letters. What do you think? I mean, this is crazy. This is all new stuff I've never heard before or seen before.
Yeah, I have seen that. I think it's part of. I haven't seen a $12,000 per image claim, but I have seen, ever since you and I spoke, the complaint, the sample complaint, being attached to the letter.
Yes.
And I guess like the best defense is a strong offense. I think they're trying to say, we don't need no stinking chaga. We don't care. We're still coming forward. It's only a trial court level decision. And, we think it's wrong and we're going to appeal it. And so, how much do you trust that case, Mr. Letter Recipient? Because we're amping it up now and we're suing for $12,000 per image. So, I mean, I think in some sense, it's going to make people maybe jump at like a $5,000 settlement or a $6,000 settlement, which I think they're crazy. Right. But at the same time, it's just more noise. It's just a louder form of what they've always been doing. And the fact that the image is rights managed doesn't matter if you don't have the right registration rights, right?
Right.
You could put lipstick on a pig, it's still a pig. So the fact that someone gave you the right to manage your copyrights, if you didn't properly register their images, what's the difference?
Hey, do that again. It's still just pretty good boss.
It's still just actual damages. You can call it whatever you want. The issue is what rights have they transferred? If you haven't registered their images properly, it doesn't change the claim at all. You can call it whatever you want. Now, images with people in them generally have higher value because you get a model release with it.
Yeah.
So that you know that the person who took the picture has the right to use that person's face. So images that have models in them from the photographer with an appropriate model release have a little bit higher value because it takes a little bit more effort, right? The photographer's not just sitting out there on his porch taking a picture of a squirrel. He's gotten makeup, he's gotten costume, he's gotten hair, so it definitely has a higher image value if it has a person in it and it comes with a model release. And by the way, it's a good point that folks who use images with people in them that don't have model releases do expose themselves to different claims should that model ever find out they never gave you that permission. They gave the photographer permission, and if you didn't get the permission from the photographer, you're using their image without permission. So you have to be very, very careful when you use pictures that have people in them of any kind. Never mind celebrities, just regular people. So I could see images with people in them have a higher value. I mean, so now you're going from, $1 to maybe $100 or $200.
Okay.
But it is a higher value that's attached to images with people. I'm just telling you now, I'll go out on a limb and say no judge in this country is going to award somebody $12,000 for the wrongful use of a digital image, unless it's an iconic photograph, like the president backstage before his speech, Mitt Romney hugging his wife after she came off. No one else has the shot. The convention's going on now. You want to be the only newspaper to publish that image. That image could be worth $10,000 without a doubt. No question about it.
Right.
Okay.
But that's not what this is.
Okay, well, we only got a few minutes left, and we're going to slide in one last topic, okay? Is that all right with you, Oscar?
Well, actually,
sure.
It ties in with what you're saying. I've seen the blank lawsuit template from Timothy McCormick. He's done it. I actually have some. And I think it's just one of those things. It's just he's sending a subliminal message. Pay us, or this is what's coming next. The lawsuit, the papers are ready. They just need to be dated, signed, filled in, done. So I think it's just, they're stepping, Nashville is stepping up their thing. And the other thing, and I haven't gotten into all the documents as of yet, but there's also an artist agreement release that's within these master files. So they're also supplying some registration information and some artist information. Naturally, I've already got a problem with the contract information because the contract is only good for 3 years. And this one I looked at was signed back in 2003. So 3 years is long gone. We don't know if this artist is still affiliated with Masterfile. They may have been for that 3 years and then jumped over to Getty. How are we supposed to know? But again, they send this information hoping that Mr. Letter recipient is going to see it and say, oh, no, they've got this contract with the artist. This is all on board. I better pay them.
And when they come... Right. And then when they come to our site and see that normally that doesn't happen, they may say, hey, these guys are doing something different. This claim is different than what I see on Eli. And they want all this money. I better, pony up the $2,500 that they really want.
Right. So, we're going to post all these documents and I'd love to see it. Do a little reporting on them and whatnot.
Well, Oscar, do you have any parting comments or any on any particular issue before we sign off?
No, just that I want to thank everybody for constantly updating, contributing, commenting on the forums, and that we want to keep Eli vibrant. And any new topics that come, forward them to one of the three of us. Will certainly have an opinion about it, and then certainly not be afraid to share that opinion. And that's it. Other than that, it's been great seeing you, Robert. Great to see you in person finally. And enjoy your trip, and look forward to the next session on Eli Factor.
Okay. Well, again, great. Well, on behalf of everybody here on the Eli Factor, thank you for joining us, and we'll see you in our next episode. Take care.
Take care.
Take care, everybody.